All right. Good morning, everyone. Welcome to OPD's 31st Annual Spring Planning and Zoning Conference. This is the Planning Board track. Welcome, everyone. Just going to give a quick intro before we get started. So the meeting controls are located in the ribbon located at the top of your screen, as depicted in this slide. There are icons to raise your hand, to open the chat box, to react, and to change the screen view according to your preference. If you have questions during the webinar, please put it in the chat, and we will try to answer them as we keep going. Camera and mic buttons are not operable during the webinar. So welcome to the Office of Planning and Development's 2025 Spring Planning and Zoning Conference. Thank you for joining us today on such a nice morning. Lots of rain. I am Brendan McDowell, Principal Planner at OPD, and I will be your moderator for the Planning Board track. There are 3 conference tracks this year with 12 sessions total. The slides and other information relevant to the session is available on our conference webpage. So I wanted to give a quick shout out before moving on. The Housing Champion designation, which enables communities to access additional funding, opportunities supporting development of affordable housing. We had 18 communities of different sizes in New Hampshire jump on this program in the first round, and the second round is now open for applications. I will put a link in the chat here once Steve starts his presentation if you'd like to go directly to the Housing Champions program for your community. So the Housing Champions designation is voluntary and available to New Hampshire municipalities. Applications are to be completed and submitted online. Application deadline is May 31st, which is coming up. We still got a little bit of time. Applications are not competitive, and applications and information are available at the website that I'll toss in the chat. For questions, contact Leanne Moynihan, Housing Finance Specialist at housingchampions@livefree.nh.gov. We were able to take registrations from nearly 450 people representing 152 towns and cities for today's conference. Welcome, everyone. These registration numbers come from communities across the state. A high resolution PDF version of this map showing participating municipalities at today's conference is available on our conference webpage, which I put in the chat earlier. So the Office of Planning and Development, OPD, the State Planning Office, it was incorporated into the Department of Business and Economic Affairs, BEA, in July 2021. In fall of 2024, BEA was restructured to create a new Division of Planning and Community Development, DPCD, which includes OPD. The Invest New Hampshire Housing Program, Housing Champions Program, and the Office of Broadband Initiatives in fall 2024. The division is led by Heather Shank. Our office, OPD, is still comprised of 4 main programs: the Municipal and Regional Assistance, Floodplain Management Program, and the State Data Center, our partnership with the U.S. Census Bureau, and Geographic Information Systems, GIS program. So our planning lunches at noon, known as PLAN, P-L-A-N, monthly webinar series are typically held on the 3rd Thursday of each month from noon to 1 p.m. Here's a list of some of the webinars we have held so far this year, along with the date of our June plan webinar titled Next Steps After Plan Approval. So the slides and recording of those webinars are available on our plan webinar page, which is accessible from our planning and zoning training page. Webinars are recorded and are offered on our YouTube channel as well. So they're available for anybody to watch at any time. All right, really quick. So here's the session chart for the planning board track of the conference with the welcome and introduction remarks finished. I'm going to pass things along to our first presenter, Steve Buckley, to talk about planning board basics. So with that out of the way, Steve, are you ready to take things away?
Ready to go.
Awesome. All right, I'll mute myself and yeah, take it away.
Good morning, everyone. Steve Buckley, Legal Services Council, New Hampshire Municipal Association. Let me just change the formatting here of how this is displayed for me. And it's not working for me. Hold on a second, everyone. I need to, one moment, while I try to just change how this is displayed. Our good friends in Microsoft recently changed a lot of the settings in Teams, and I had this set up yesterday, and it's not allowing me to do what I want. So I won't bother. I will just squint and look at the smaller slides and do the best I can. So again, Steve Buckley, Legal Services Council, New Hampshire Municipal Association. So what I have done in many presentations for planning boards is put together what I think is to be the basic elements of what a planning board needs to know. And I've added slides, deleted slides over the years, and really tried as much as possible to include the most current content of the things that are important for planning board members, individuals, the whole board to know about, making sure it's doing its job, consistent with the statutes, consistent with the decisions of the New Hampshire Supreme Court. So this is my latest iteration of that way in which I think we as land use board members, because I'm also a land use board member, I was on a planning board for a number of years. I'm also on a land use board now in my town as the ZBA. So I think these are the things that I think are really worthy of note and merit attention by land use board members. So what I've done is try to boil this down to what I think to be kind of the essentials of what you need to know. But I always feel it's important to start out with the duty to assist and conflicts of interest, and then to address statutory duties, subdivision size plan, master plan, workforce housing, et cetera. And then some of the kind of nuances of the processes that you have to follow for review, application receipt, timeline review for review, et cetera. So that's the plan for the presentation. And so what we're going to do today is go through these slides, and then with Brendan's help, we'll then address any questions you might have with some reserve time at the end. Hopefully we'll have about 15 minutes of time to go through your questions, which in this instance you're putting into the Teams chat, and we'll try to address as many of those now or before 10:15 when this section will wrap up. And then if those that are not addressed, we'll address them later on in the part of the program when the call the planner is in, which will be later on this afternoon. This issue about the duty to assist was actually a subject of addressing by the New Hampshire Supreme Court. What is the duty to assist? But this just generally understand the New Hampshire Supreme Court has made clear, based upon the New Hampshire Constitution, that land use boards have a duty to assist the citizenry in understanding how to interact with a complex, somewhat complex, planning and land use system and to achieve reasonable use of their property, because people who own property have the right to use it reasonably within the confines of, again, reasonable regulations adopted by your municipality. And so I, I think it's important to keep in mind it really should not be an adversarial process. It should be a process where ultimately, I think it should be the board's expectation to get to yes, to help the board, the applicant, to get to an approval based upon the board's regulations. And to that degree, it does include some duty to advise the applicant on how to work with the planning board or the planning board staff, as the case may be. And typically, this is addressed through the planning board having staff to provide answers to people who come in and want to know how things work and how they address things at the counter, so that when the person files the application, things can move smoothly through the application acceptance and approval process. I would just mention there was recently the Supreme Court addressed this issue in I guess you would call this a case order. It's not normally a published opinion, but in the matter of My Way Realty versus City of Manchester, a decision that came down April 14th, the court touched on this duty to assist, because in that case, the applicant had finished his presentation, and the whole board had moved into the deliberative process and essentially had closed the public hearing. And then while the public hearing was the deliberation session was going on in front of the planning board, the applicant heard something about, lack of traffic engineering studies, and then during the deliberative part of the process by the planning board, the applicant's attorney popped up and said, "Gee, I can get you a traffic study. I want you to reopen the application process, or actually the public hearing, so I can submit it." The board looked and thought about it and said, "No, that's not reasonable under the circumstances." And ultimately, both the Superior Court and the Supreme Court agreed, that this was not a violation of the duty to assist. So if you get to the end process of maybe a complicated and lengthy public hearing process, and you've closed the public hearing, you've decided you've got the evidence you need to make a decision, and then all of a sudden, out of the blue, an abutter or an applicant says, "I want to submit new evidence," you probably have a right to say, "No, I think we've done enough, and that's not necessary at this point." So it's a worthy thing to keep in mind. The court does take knowledge of that concept in deciding whether or not the board is acting reasonably from a procedural point of view. Conflicts of interest is important for really two things. Under this statute, a planning board member who's acting on an application for subdivision or site plan approval, or maybe an application that your board has been given the authority to grant conditional use permits, cannot participate if the board member has a personal or pecuniary interest. Personal interest, the applicant is a relative. Pecuniary interest, you're an abutter or you have some kind of financial potential interest in the outcome of the decision by the board. But then the board also has a duty to ensure it does not have a conflict that would be commonly understood by referring to the things that judge the merits of the ability of a member of a pettit jury, the people who are sitting to be selected to sit on a jury, things that would disqualify them from sitting on a case. And so we always go to that statute to look at the things you have to be aware of. Do you expect to gain or lose because of the application? Are you related to any party? Have you advised or assisted either party? Have you directly or indirectly given your opinion, or have you formed an opinion? Are you employed or employed by any party in the case? Are you prejudiced to any degree? And are any of the attorneys appearing, if there are any, are those that you had employed as your own personal attorney? If any of these things pop up, it may be worthwhile to consider that you should recuse yourself from that particular application. The Z1 Express case is really the one that I think best expresses the need to avoid conflict of interest, which dealt with a member of the planning board, actually it was an alderman sitting in an ex officio capacity, participated in the matter, but then also posted comments on a website which was dedicated to opposing a proposed project uh, by those who were opposing a gas station nearby residential area. And by posting messages on that website, before the board had made a final decision, and saying that through the alderman's statements on the chat portion of this particular Facebook page, I assume it was, that he supports the abutters and he opposes this project, that jeopardized clearly the ability of that alderman to be fair and reasonable under the circumstances because he had prejudged the case. The alderman was asked to recuse himself when the board next convened to make a decision. The alderman refused. The case gets appealed. After the board denied the application, the Superior Court said, you can't do that. You have to recuse yourself. So the matter was sent back to the board for a decision without that alderman participating because he had already formed an opinion. So it's an important thing to keep in mind. I think the key thing to take away from this case is avoid social media. Not a good idea for land use board members to be either joining a Facebook page that's on a subject of potential interest on an application, or certainly posting comments. If you do have a potential conflict of interest, a number of things you can do, or you're concerned that someone may argue you have a conflict of interest, you could ask for an advisory vote from your fellow board members. Here's the situation, board members. What do you think? Do you think I should recuse myself? And if your board members all tell you probably should, you might want to think about doing so. Now, only you or a fellow board member can do an advisory vote. The abutters or applicants can't ask for it. So if you have that situation where maybe you're being asked or suggested by your board members to recuse yourself, recuse, but don't abstain. Abstaining really doesn't achieve much in terms of avoiding a conflict of interest. You have to recuse. As I've already said, avoid social media opinions on pending matters. Disclose and remove yourself if necessary, and really err on the side of caution, because you don't want your board to have to go back and do it all over again, especially on a very contentious matter. The one thing that is important to keep in mind about recusal, it is ultimately a decision made by the individual board member. The board member can't be forced to recuse him or herself. Generally, I think is to keep in mind that, when we're acting in official capacity, you are allowed to use information of a general nature that you would gather as a citizen in your community. So that doesn't disqualify yourself just because you have gathered that information. In fact, we recognize, and in fact, in my town, we tried to get planning board members from different parts of town because you bring to the proceedings a knowledge, or more particularized knowledge, of your part of town and how a project might be affected by how that would affect the neighborhood that you live in. And also keep in mind that the decisions that you're making when it's on a matter involving a judgment of the merits of an application where there's proponents and opponents, you're acting like in a judge-like capacity. Therefore, you really have to avoid, as much as possible, the appearance of bias or prejudgment. A little different if you're talking about legislative decisions. So if you strongly support a particular zoning amendment and voice those points of view at the public hearing that you have to have as a planning board member, when that zoning amendment passes and you're called upon to interpret it, say, with regards to a subdivision or a site application, just because you had strong opinions voiced at that public hearing doesn't mean you have to recuse yourself, because you were acting in that instance in a legislative capacity, not a judicial capacity. So to summarize, in kind of one kind of slide inventory of the duties and responsibilities of a planning board, I've tried to put the most important ones here. Planning boards are doing the master plan. Many times the planning board is also doing capital improvement planning, or it could be a capital improvement planning committee appointed by the select board. Planning board recommends the first zoning ordinance and proposes amendments. Planning boards do subdivision regulations, and if you have a zoning ordinance and have adopted subdivision approval, the town may also have given the planning board a power to approve site plans for the development of multifamily and or non-residential uses of land. Planning boards sometimes are the excavation regulator. The default setting, I believe, is the planning board, if I'm not mistaken, but it could also be delegated to the select board and or the ZBA. And the planning board it's kind of a shared responsibility, should be involved, or it, at least for the purpose of adopting regulations, might be involved in driveway regulation, although the actual issuance of permits might be delegated to the road agent and conjunction with the select board. I think the main thing I want to emphasize about the master plan authority of the planning board is that if you're going to have a zoning ordinance, you have to have at least two sections of the master plan adopted. The vision section that articulates the desires of the citizens and guiding principles for how the town wishes to be developed and land uses are supposed to be organized. And then you have to have the land use section that studies population, economic activity, resources, and shows existing conditions. These are, as indicated, prerequisites to the adoption of a zoning ordinance. And then there are 14 optional elements and a new one, which is now suggested as an optional section of your zoning ordinance, something, a section dealing in your master plan with solid waste reduction plans. Subdivision and site plan approval is really probably the main business of the planning board. Subdivisions are the divisions of land. So you approve plans for the divisions of land and showing streets and showing utility facilities and other services necessary to support typically residential housing subdivisions. There are some subdivisions, things which look like subdivisions which aren't subject to subdivision approval. So if a piece of land is divided by order of the probate court or the probate court system, circuit court probate division, that would be a division of land which wouldn't require planning board approval because it was approved by the probate court. And there are some where there's always a debate. I know in a number of instances when we receive inquiries at the Legal Advisory Service, there was a question as to whether or not the state of New Hampshire had to go through subdivision approval for a division of land related to they were breaking off a piece of land that was part of ultimately the rerouting of a state highway. And I ultimately came to the conclusion with the planner and also consulting with some other attorneys. We agreed that at a minimum, there had to be a subdivision recording to show the division of the land, certainly for the purpose of the town updating its tax maps. Whether the state of New Hampshire had to go through complete and detailed subdivision approval process for the planning board, I think what I concluded ultimately, I think it would be kind of a modified process, but certainly no plan showing a division of land in a town where that town has a planning board. The way it works, when your planning board has been authorized by vote of the town meeting to have subdivision approval authority, that then results in the recording of the resolution by town meeting that in our town we have a subdivision regulation and we have the planning board who has to approve divisions of land. Once that happens, the Register of Deeds cannot record a plan unless the chairman of the planning board has signed the plan. So in the instance with the state of New Hampshire trying to divide land, basically we concluded, well, the planning board's going to have to prove some kind of a plan because they can't divide that property without a plan signed by the planning board recorded at the Registry of Deeds. And then, of course, there's site plan approval. You have to have zoning to have site plan approval, and the planning board has to have adopted subdivision regulations. But then the planning board can approve or disapprove developments or change or expansion of use of developments for non-residential uses for multifamily dwellings, which is dwellings more than 2 dwelling units. I would say just briefly, as indicated on the next slide, uh, planning boards can, as part of the development review process, do a series of things which probably, especially for towns that don't have a lot of staff, is a really good way for the board to address issues without having to worry about the standard timetable, approving plans within 65 days of plan acceptance. So planning boards can mandate, but you have to mandate it, conceptual consultation. And I think conceptual consultation is a very elegant way to get an applicant before the planning board, have an opportunity to have a frank discussion about the interests of the applicant and the town's concerns. The statute allows you to have conceptual consultation without timeline constraints, and it also says that you're not necessarily bound by what the applicant says or by what you say, but it allows a frank airing of views. So if you wanted to do that and require that every applicant had to come to the planning board for conceptual consultation, you would need to have your town meeting vote to mandate preliminary review, including conceptual consultation. So again, it's a non-binding process. You don't have to notify abutters, and I think it's a good way to get the exchange of information between the applicant and the town before the applicant has spent a lot of money on engineering studies and engineering designs, and when you have an opportunity to most effectively have an impact on the final design process. Because many times, once an applicant has spent all the money putting the plans together, they tend to be a little reluctant to make changes because a change to a plan does incur some additional expense for the engineer or surveyor that they're using. So it's just one way to consider how to, I think, effectively, A, not be bound by timetables, and B, try to get a shared understanding of what was going to work in front of the planning board when the actual formal application is filed with the planning board. And finally, there's design review, which is kind of a middle road between conceptual consultation and actual approval. It does not require a public hearing, but you would be required to give notice to abutters. So there's a kind of a midway point called design review, and you get some protections from changes in zoning regulations during the design review process. I'm not clear on how often it's used as an optional review process under 676:4, but it's one of the options the board can consider. The planning board's role also, and most importantly, involves the principal obligation to address zoning amendments. So just to confirm and understand about zoning amendments, there's really only three ways zoning amendments can be proposed. They can be proposed, of course, by petition of the residents. They can be proposed by the select board, or if it's a village district, if the village district with zoning authority, its zoning authority in that particular municipality can be proposed by the village district commissioners, or it can be proposed by the select board, as I've already indicated, that primarily zoning amendments are coming from the planning board. And I would just encourage planning boards to, reach out to your code enforcement officer, building inspector. You probably already do this, land use staff, and certainly the zoning board of adjustment. What are the things in our zoning ordinance that creates questions, concerns, or problems, so that when you're considering zoning amendments, which is typically somewhere between August and November of the year before the following year town meeting, you can get some good input in deciding how you would propose or what you should propose as zoning amendments. And the planning board has a very important role in that process, because any zoning amendment proposed by the select board, governing body, or proposed by petition has to have a notation on it as to whether or not the proposed amendment is approved or disapproved by the planning board. And that becomes a notation on the ballot question when it's submitted to vote on the official ballot, which is out on the official ballot voting day, which is either the second Tuesday of March, second Tuesday of April, or the second Tuesday of May. CIP planning is, kind of an essential tool for a town to develop a common understanding of what are the things that we need to improve in terms of our capital infrastructure, and how should we go about planning for those improvements, whether it's the purchase of large equipment, or it is the improvement of certain road systems, or the renovation or construction or reconstruction of town buildings and facilities. The capital improvement planning process allows the planning board or a CIP committee to develop a plan for the long-term improvement of your municipality, capital improvement. And that could, so what I would just point out, which is important to keep in mind, a CIP is merely a series of recommendations to the budgeting, typically the budgeting side of the municipal administration. So the budgeting in your town is done either by the governing body and or a budget committee if you have an official budget committee. But even if you have an unofficial budget committee, those agencies, select board, budget committee, unofficial budget committee, can and should receive recommendations from your CIP committee or the planning board on what should be considered in terms of capital improvements. And typically that comes along with recommendations for setting up savings accounts, capital reserve funds, so that when you need to buy that new plow truck, you've already put that money aside over the last couple of years, and you can better control the impact on the tax rate for those capital improvements. The CIP ultimately is merely a system of recommendations. It's not binding, but it would perhaps be and should be influential to the budgeting administration side of the town when the town meeting when the select board in conjunction with the budget committee is drawing up the town's operating budget and or separate warrant articles for things such as acquisition of capital equipment. One of the other kind of facilitated ways in which by statute we've made it easier for citizens to address a proposal that they would like to have undertake without too much expense is to merge lots. So this statute, I believe it was adopted about 15 years ago, to make it a simpler process for someone who owns contiguous pre-existing parcels of land who wishes to merge those parcels for zoning and tax purposes to do so through a simplified process. And it doesn't require ultimately the hiring of a surveyor to survey the lots and to submit a plan to the planning board. It is simply and in fact, for many municipalities, this has been delegated not only to is delegated to the staff rather than the planning board to review the request by the person and then to approve it for recording a notice of merger of lots, recording at the registry of deeds. One thing I would just emphasize, and I've emphasized this on the slide, the lots that are being proposed to be merged have to be contiguous, which means they have to touch each other. And one of the more common questions that we receive in the legal advisory service from NHMA is whether or not someone who owns property on both sides of a road, could be a class 6 road, could be a town road, where theoretically they own to the center line because the roadbed is merely a viatic easement, an easement over private property, and that since they own technically to the center of the road, that must mean that these parcels are contiguous. And my answer is no, that's not contiguous. Contiguous means both sides of the road have to touch, and the intervening viatic easement would not qualify that parcel, those two parcels, to be on both sides of a public road to be contiguous. They have to touch each other in order for them to be deemed contiguous. So no public hearing is necessary for the notice to be approved. No survey plat is needed to be recorded. The notice can be endorsed either by the planning board or the planning board's agent. But one little trick about this merger statute, if either lot is under a mortgage, you have to make sure the lender that is got the mortgage on one or both of the lots consents to that merger. And so typically what you want to have happen is have the proponent of the merger, the property owner, affirm under oath that neither of the properties are subject to a mortgage, which may be actually quite well indicated in the town's tax records. And if you do have evidence of a mortgage, you're going to have to get the proponent, the property owner who wants to merge these lots, to get permission from their mortgage lender and have that recorded with the notice of merger. As I've indicated, driveways are also an area of potential planning board regulation, and I think this varies by community. And it may be that in your community, all driveway either regulations and or permit issuance is handled by the Select Board Public Works Department and or road agent. But what the statute says, and this is RSA 23613, the planning board or the select board can approve driveway permits in the same fashion as the Department of Transportation approves driveway permits on state highways. You do need to have driveway regulations. Now, I've seen it in towns in a number of situations where the driveway regulations adopted by the planning board, but then from that point forward implemented and managed in terms of permit issuance by the road agent, public works department, and or overseen by the select board. So that process, as indicated, can, as indicated, be delegated to those agencies instead of the planning board doing all of the activity. And then it is important to understand that the planning board or the enforcing agency has continuing authority over that driveway. So if a driveway, even one that was never issued a permit, becomes a hazard to the traveling public because the driveway, the incline of the driveway to the adjacent town road is so steep. There's problems with water being cast down the steep driveway onto the adjacent public road, or the drainage system is causing soil and other materials be cast onto the public road, which is a problem because if it freezes, it creates an ice patch, which is a hazard to the traveling public. But it also could be just a matter of a drainage problem undermining the adjacent public road. So any of those attributes can be a basis upon which enforcement can be undertaken, where the town says, fix your driveway. Yeah, we didn't originally give you a permit, but your driveway is not a problem. And I think also part of that process should include being ensuring that driveways are situated in appropriate locations so that they have the driveway has appropriate line of sight, taking into account the speed of the traffic on that particular road. Planning boards have been given very specific authority to require offsite exactions. And I'm not going to go through a detailed summary of the history of impact fees, but I would just say generally, it was back in the 1990s that the legislature eventually decided that it was necessary for towns to have the authority to ask new developments to pay their fair share or capital infrastructure costs that would be imposed on municipality uniquely caused by that particular development. And the easiest one to understand, when you're putting in a large commercial development on a road, it could create traffic circumstances that really justify that the entrance to that commercial development have a traffic light to avoid problems with traffic stopping, starting, and entering and turning left-hand turns from the entrance to the shopping center, if that's what it was, or coming into the shopping center from the adjacent public road. So we recognize that there's a unique need to have those kind of improvements when necessary. And there's been a number of legal cases about, well, what is the authority of a town to do this if the town has not adopted an impact fee ordinance? And due to those cases, it was recognized that there was a need to give specific statutory authority to the planning board for certain types of offsite improvements which are deemed necessary for a particular project. So this authority, 674-21, paragraph 5J, which is also part of the Innovative Land Use Control Statute, does not require the planning board or the town to have an impact fee ordinance to impose an exaction. And an exaction, I suppose, is kind of a misnomer, but it's designed to have the project bear the infrastructure costs that the town alone should not have to bear for a particular project, such as I've indicated, the traffic light going into a large commercial development. But as the statute provides, these are improvements for off-site. So what the on-site improvements are everything no one doubts are the responsibility of the project proponent. So the person who is building the strip mall or the commercial development, they have to deal with all the on-site improvements and the parking and lighting and the landscaping and everything else. This is off-site improvements and necessitating those requirements to be shared, perhaps to be shared in part or wholly by development, is subject to the rational nexus test, which is just a concept which the U.S. Supreme Court has imposed on towns and municipalities when they ask a property owner to pay for improvements. Those improvements under the rational nexus test has to be reasonably related to the impact that project is causing on a town, and the cost thereof is calculated to ask the project developer to pay their fair share of those costs. There was a case recently on the U.S. Supreme Court, which I can't cite the name of the case off the top of my head, but it was a situation in a county in California where the county had developed an impact fee system to require all new homes, all developments to pay their fair share for what they call the traffic impact study. So this gentleman, he asked to build a new home on a small lot. Actually, it was a pre-site built house. He was just going to situate it on the property. And the county said he had to pay a $25,000 impact fee assessment. And it was not really rationally related to the actual impact that home was going to have on the adjacent road. It was just a number that the county had calculated for all development, really without regard to what was the specific impact that project has. And the Supreme Court just reemphasized, and this had to do with whether this was an administrative burden imposed or a legislative one. The Supreme Court should emphasize you have to abide by the rational nexus test. You're going to ask someone to pay for an offsite improvement, which is really going to be within, in most of the time, within a municipal right-of-way or in municipal infrastructure, has to be rationally related. And how do you determine what's rationally related? Well, you might be doing it based upon traffic studies or any other attributes of how that particular activity is going to impose some demand which exceeds the current carrying capacity of that particular municipal improvement. So the easiest one to understand is, there's a lot of ways to study how a particular use of land, let's say a, a, a a new Dunkin' Donuts, how much traffic a Dunkin' Donut generates, and how it affects the need for widening a road or putting in an XL or decel lane or other things which are necessary to maintain appropriate traffic movement and traffic safety. So the planning board has this authority, but again, keep in mind, this authority to require an offsite improvement is limited to highway drainage and sewer and water upgrades. What you can't do under this statute is tell someone, you've got to give us enough money to help purchase a hook and ladder truck for our fire department. That's not going to fly because that would not be one of these areas where an offsite exaction can be imposed. It's, I think, important always for planning boards to understand what does it mean when you do plan acceptance. So the key understanding that should be brought away from this presentation, and probably something you've already learned, the planning board's formal process of considering a subdivision or site plan does not start until the planning board has voted at a public meeting that the plan submitted, the information that was in your subdivision or site plan checklist or your regulations, what has been submitted reasonably provides the information we need to accept the plan as complete. That is complete, meaning we have what we need to then open the public hearing process and eventually approve or disapprove the application. So that plan acceptance process typically is, in many municipalities, it really is mostly done by staff going through a checklist and then telling developer or project proponent, yeah, it's ready for plan acceptance. Let's schedule plan acceptance and possible public hearing. But this is another area where if you don't have that staff, how do we accomplish a reasonable assessment without having triggered timetables such as 65 days from plan acceptance to approval or disapproval? Again, I think you could use conceptual consultation. If you have a process where you require people to come to the planning board for conceptual consultation, you could also sit down with the developer at conceptual consultation and go through the checklist and see what they've submitted and give them a heads up. Yes, we think this is ready for plan acceptance, and then you can schedule it for plan acceptance as public hearing. But ultimately, as I've indicated, you have to make this decision to accept the plan as a completed application. And this is a public meeting, not a public hearing. So whether or not you're going to invite the public to comment on the plan acceptance. That's really up to the planning board. But many boards really structure it so that when you give a notice to the applicant, to the abutters, and to the public at large, the notice says, we're going to schedule plan acceptance on this day, night, evening, and then it would further say, if the board finds that the plan is complete, the board will then go directly into the first public hearing. So you can do plan acceptance and public hearing at the same time. The effective plan acceptance, again, keep in mind, once you've accepted the plan is complete, you've got 65 days. And if the board does not take action within 65 days to approve or disapprove, and if you can't get a consensual extension of that time from the applicant, you could be in a situation where the matter will be taken out of your hands, and the decision has to be, the applicant has to be approved by the governing body, select board, or city council or town council. You might be able to squeeze in another 30 days under the regional impact statute. So the regional impact statute and the statute governing timetables for planning board action, does contain this provision. If the board determines, maybe a plan acceptance, maybe beforehand, that you had come to a conclusion this was a project that was going to have regional impact, you can tack on another 30 days, because the statute realizes, in order to really then incorporate the participation of the Regional Planning Commission and the embodied community, you have to give them notice, and that slows down legitimately the process, but only to afford that participation under the regional impact statute. So you do get an extra 30 days. And I'm not encouraging you to say that all projects should be deemed ones of regional impact, but if you do it, this at least is not you're not penalized because you have to spend more time sending new notice to the abutting community and to the Regional Planning Commission. Do keep in mind, though, that the statute does have, I guess, the term of art these days is there's another off ramp. So you're at a point where you've used up your 65 days, you can't make a decision, you feel like you need more information, and the applicant refuses to give it to you, the applicant refuses to give you an extension. You do have an option to make a decision and deny the plan without prejudice, so the applicant can come back another day, file another request. And that avoids some of the penalties that can be imposed where the governing body approves the plan and or it gets sent to the Superior Court, and you end up having to have the town to pay attorney's fees and expenses. So you are in that situation, you do have this right, the ability to then move ahead with a decision, which is a decision without prejudice, and deny the plan along those lines. So I feel it's always important to go through this slide to just remind ourselves, what is the timetable for the process of handling subdivisions and site plan applications. So as I've already indicated, preliminary review is not subject to a timetable. So if you have had the town meeting, voted to give the planning board the authority to require preliminary review, including conceptual consultation, and that has to be adopted by the town meeting under RSA 674:35 Roman 1. It'd be a separate warrant article. It's not a zoning amendment. It's to see if the town will vote under RSA 674:35 Roman 1 to permit the planning board to require preliminary review and consultation of subdivisions and site plans. That's the warrant article that you would have the town meeting adopt, and it would be on the regular warrant, or it wouldn't be on the official ballot. If you're an SB2 town, it'd be on the official ballot, but it wouldn't be on the zoning part of the official ballot. So that's what has to be adopted. The applicant has to submit their materials for arguing that they've got a completed application at least 21 days before the acceptance meeting. Then you have to give notice to the abutters and the public 10 days before the meeting for plan acceptance. And I always feel it's important to remember, yes, it's a good idea to do newspaper notification, but if you read RSA 676:4 carefully, and I think this is in Roman 1D1, that has the provision for notice to the abutters and the public. It says, notice shall be provided in two public places, and as required by the subdivision regulations, newspaper notification. So if your subdivision or site plan regulations do not require newspaper notification, you're not required to do it. Now, I'm not necessarily arguing to get rid of newspaper notification because I'm kind of a newspaper kind of nerd and I read a lot of newspapers every day and I always check the public notices. And some other people are the same way. But that what I would say is it is not necessarily required under the notice statute to give newspaper notification. It may be buried in your subdivision regulations, and if it's there, then you've got to comply with your subdivision regulations to get a newspaper notice. But if it's not there, you're not necessarily required to do it. And then you then have to hold at least one public hearing to approve or disapprove within 65 days, then issue a written decision within 5 business days. There are certain circumstances where you may not need to have a public hearing unless it's asked for. Also buried in the statute is a recognition for when someone is doing a lot line adjustment or a circumstance where the subdivision is not creating new buildable lots, you're not required to hold a public hearing unless it's requested. But you would have to give notice that the board is going to act on a project that is not one where a public hearing is required prior to holding that public meeting. And then, of course, what could happen in a butter would say, I want a public hearing, and then you have to grant it. So there is some ability to have a modified process. We're dealing with whether a public hearing is necessary, but this is only, again, for situations where someone's doing a lot line adjustment or a situation where you're not creating new buildable lots. The other thing about plan acceptance, which has an aspect to understand, is the concept of acceptance vesting. That's something I cooked up as a concept because it really derivative of the necessity of recognizing, and this is in the same statute, RSA 676:12, which we get a lot of questions about all the time. When does a proposed zoning amendment go into de facto effect? We talk about that in a second, but the acceptance vesting concept is this. Once a plan has been the subject of notice by the planning board that it's going to be considered at a plan acceptance meeting and or public hearing, once that date of that notice has been issued, any subsequently adopted or proposed regulation, change to your subdivision or site plan regulations or proposed zoning amendment will not apply to that plan because that plan is entitled to be considered based on the rules in effect when they submitted the documentation, which would have been justifying the town to schedule a plan acceptance and or public hearing. So it's a concept which then recognizes, I have a right to know that the rules of the game that apply to my plan are only apply based upon the date I submitted the application, and then the town gave notice of the plan acceptance or public hearing. And by the way, just so you understand, the concept under 676:12 also deals with, what happens when the planning board has posted notice of a public hearing on a zoning amendment. Does that zoning amendment go into de facto effect? Meaning, does the town implement the zoning ordinance? This is the way to understand that provision. What that provision is intended to do is to avoid a run on the building department for permits because there's going to be a change in how the zoning affects the ability to use land. Typically, it's a use change to a zoning ordinance, but it could be a dimensional change to a zoning ordinance. So the theory here is if after the planning board has given notice that the board is going to change in a particular zoning district uses of land that are allowed, what does it mean for me if I apply for a building permit after that notice of that proposed zoning amendment? Well, the building inspector is then supposed to decide if the amendment as proposed gets adopted, would it be the case that I would have to deny this building permit? And if the building inspector answers that yes, let's say that the change is we're going to eliminate in the zoning district that you can use in this particular commercial district, you can have restaurants such as a Dunkin' Donuts. We've got too many of them already, and we're going to put most of those kind of restaurants in a different district. If someone came in to build a Dunkin' Donuts after that notice of zoning change would eliminate that as an option for the parcel that person owns, the building inspector would say, I can't issue this permit until we know what happens at the town meeting. And if the town meeting adopts that amendment, well, then the building inspector would issue a denial. It, temporarily, what the statute says is the proposed permit issuance would be held in abeyance. But then, if the zoning amendment is defeated, is not adopted, because everyone likes Dunkin' Donuts, then the building permit would be issued. So it doesn't mean that the proposed amendment goes into de facto effect. It just affects the period of time that the decision maker is either holding the decision in abeyance and waiting for the town meeting to make a decision as to whether to approve or disapprove that particular application or that particular zoning amendment. There are some other things I would also mention about alternative site plan review and approval procedures. Larger towns in particular will sometimes have a group called the Technical Review Group or Technical Advisory Group, whose job it is to bring together town department heads, water, sewer, police, fire, health, land use, and representatives of each of those departments have a meeting once a month for applicants to the planning board to sit down and go over their application and to be told what are the concerns that the different departments have or the issues that that person applicant, developer will face in front of the planning board. So it's a technical review group, but it's not there to make decisions for the planning board. It's there to provide advice to the applicant alone. And that actually is not a public meeting, so the public isn't necessarily allowed to attend those meetings. The town meeting can authorize the planning board to delegate minor site plan review powers for site plans of a minor nature. Maybe it's a minor modification to an existing site plan or a small site plan development where that can be delegated to the planning board to what's called under the statute technically qualified administrators. But the last one that I think is really important for planning boards to address, and this can also be addressed by town meeting, you can decide that there are certain thresholds or size of a project below which site plan review is not really necessary. So if you've got an existing strip mall and the developer or owner wants to add a couple of new parking spaces that doesn't significantly impact the area of land, the degree to which the land is subject to impervious or non-impervious soils, or it's a slight change to the landscaping or immaterial changes to lighting, or maybe even adding, a certain amount of additional floor space, maybe 1,000 square feet of floor space, where it's immaterial for the planning board to then require site plan review. So either the planning board or the town meeting can dictate that there are thresholds of development below which further site plan review or modified site plan review is not required. And I think that's something worthy of consideration because you just don't want everyone, the way the statute is worded under site plan review, change or development of use or change of use. What's considered a change of use? So I think it's a worthwhile thing to consider for the board to describe this, either as part of the board's regulations or for their town meeting to amend the planning board site plan review authority to provide for a minimization, not needing to have site plan approval based upon a project of minimal impact on the community. I've already talked about developments of regional impact, but I just want to go through the process with you. So when the board has come to the conclusion a project could reasonably be expected to impact on neighboring municipality within 5 days that making that judgment. And when do you make that judgment? Well, it could be a plan acceptance. You just decide this is a project of regional impact. And so if you've scheduled the project that night for plan acceptance, and you've also said you might go into public hearing, you may have to stop at that point. Well, we'll do plan acceptance, but this is a project of regional impact, and we've got to notify the Regional Planning Commission, and we've got to notify the abutting community. And then there is a process where they have to be given an opportunity to be heard. I believe it's a 14-day notice, at least 14 days for the next public hearing. And that's part of the reason why you get an extra 30 days on the plan review process if you make that judgment. So it is a good idea to deliberately consider this issue, and if making that judgment, you reasonably concluded because of the impact on either roads or shared facilities or other attributes of the project, especially if it's geographically near the abutting community, where you might want to make that judgment in favor of declaring it a development of regional impact and give the Regional Planning Commission the opportunity to be a participant as well as the abutting community. So it's worthy of keeping in mind, because there are Superior Court cases out there where a planning board did not declare a project one of regional impact, and the decision of the planning board was overturned for failure to do so, and to give notice and opportunity to be heard to the Regional Planning Commission and to the abutting community. So it can have outcome determinative impacts if you don't reasonably conclude a project is one of regional impact and fail to allow the community and the affected community and the RPC to participate in the project development and review and approval process. A few things about public hearing rules. You really should have written public hearing rules, because it sets forth in RSA 676:4:1 that you have to have rules of procedure. A couple of things I think keep in mind. You want to perhaps have the applicant have a time limit. I've been at planning board hearings where it really feels like the applicant is filibustering the public hearing process and is taking an hour and a half, and is chewing up so much time the abutters are not going to have a chance to be heard. So may depend on the project in terms of its complexity, but it might be something to consider. Do abutters, easement holders, directly affected persons, do they have a time limit? 5 minutes, depends, on the project. And I think the board has to be reasonably considering, the impact of a particular project and who you feel really needs to have more time to be heard. Be flexible, but also recognize, you've got volunteer time and you don't ever want to go beyond a certain point in time. So we had to develop a rule in my planning board. This is during the go-go 90s. We had to say, because sometimes we were having public hearings till 1 o'clock in the morning, and it was a killer, that we're not going to start a new matter on the agenda after 10:30 or 10 o'clock, because we just don't want board members, especially if they go to work the next day, have to be up late at night addressing an application. Plus, it's really hard to concentrate when you've been sitting for 3 hours and it's going on 11 o'clock and you're still hearing testimony. So that's one way to deal with this I would recommend. And then, are you going to let an applicant, to have a rebuttal? And I think ultimately you should try to make sure the testimony is germane to the plan, the applications before you. What about alternates? What's their role? Well, this goes back to your rules of procedure. Should alternates be allowed to participate? You need to say that in your rules of procedure. I think it makes a good way to inculcate an alternate into the culture of your board, to allow them to participate in the process, to ask questions, to be considered part of the board during the whole process, because many times it's the alternates who are going to be brought up to become regular members, and that experience being an alternate can be invaluable. So they should be permitted to ask questions. But once the public hearing is closed, typically, from my recollection, once you've gathered all the evidence, the public hearing is closed, rebuttals are over with, and the matter is brought back to the board to make a decision and have an internal or a public discussion in front of the public about the board's consideration of the application. At that point, the abutters' participation should stop. They're not really a decider, and I think they should. They've had a chance to ask questions, but they really shouldn't be part of that material discussion as the board's trying to come to a decision. Who has the right to be heard at your public hearings? Well, it is very clearly set forth in the statute. At the public hearing, any applicant, abutter, holder of easement interest, or any person with a direct interest in the matter may testify in person or writing. the statute goes on to say other persons may testify as permitted by the subdivision regulations or the board of each hearing. So I think you have to be reasonable under the circumstances and allowing people to present testimony. But if you have a room full of people, most of whom are not abutters, maybe even out of town interest holders, maybe not even an affected community because it's not a project of regional impact. And you really can't see how the project is going to have an impact on any of the people who want to testify, who are not within that category of those you have to hear from. You might have to reasonably decide that we're going to, limit participation. However, one of the other tricks of being a chair of the uh, planning board would be maybe you allow one of these really non-involved persons who really can't show they're impacted by a project. You let that person say a few words. You say, okay, for the rest of you who really aren't really near this project or the butters, would you agree with Mr. Buckley, who just agree or disagree with what he just said in front of the public, in front of the planning board? And if they raise their hand, say, great, thank you. I'm glad to hear that that's the case. We'll note that for the record, and we'll, close the public hearing at this point or move on, as the case may be. That would be kind of one trick that you can address when you're dealing with trying to deal with a huge room of people and deciding who has a right to be heard. But this is the bare minimum. It's the applicant, the abutter, the holders of easement interests, and any person with a direct interest in the matter. Direct interest would typically mean I can show I'm affected by this project. I'm affected by its size and dimension. I'm affected by traffic, whatever the case may be. So you're deliberating and weighing the evidence. You've heard all what's going to be heard. The matter's back before the board. Make sure you get the information you need before closing the public hearing. That my way case, I think, is one to keep in mind. Just what happened. Again, remind you what happened in the case. The board was having its discussions. It was deliberating. It was considering what to do, and obviously, it's done in public. So the board was talking a lot about traffic concerns. And then, in the middle of that discussion, the applicant's engineer says, I'd be happy to get a traffic report and submit it for further evidence. And the board was then sitting there saying, well, are we going to reopen the application, take more time, have another public meeting? Are we going to have, the abutters submit their competing supplemental traffic report? In that particular setting, the court did not conclude, either the trial court or the Supreme Court, that it was a violation of the duty to cooperate and assist the public to have the application uh, reopened to receive that traffic report. So it is important to get all that information. On the other hand, you might decide at a particular point in time there's an unknown issue that you cannot resolve, and you might decide because there's been a proposal to reopen the public hearing by an applicant or a butter, maybe you do reopen it. But I think you should have done it advisedly, especially when you're bumping up against your deadlines and you don't have a consent to extend the time period. So that can be an important decision when you close the public hearing. The board doesn't have to vote that night as long as you have more time. You can deliberate and think about it, deliberate individually, not amongst other board members outside the public hearing or meeting process, and then you come back another day to make a decision. Um, Really, if you're going to do that, just avoid all ex parte any contacts with any of the involved parties between the date of the meeting when you close the public hearing and the date of the meeting you're going to deliberate. Um, and the board can and should rely on your personal knowledge, and that personal knowledge can overcome the opinion of experts. Um, but if you're going to reject all the opinions of, if all the traffic studies say, the town's traffic study and the applicant's traffic study all say that this project does not need any particular new road or improvement to an offside road or offside exaction, but you decide to require it anyway, you could have a problem because you really can't ignore an uncontradicted expert testimony. And I would just urge you to keep that in mind. Although I would just mention a case where a ZBA was able to use its own personal knowledge to basically determine a proposed traffic study was not accurate. And the main reason why they were able to demonstrate it was not accurate and therefore reliable, which was based upon the testimony, board members pointed out the traffic study was done in May when the project was a recreation resort activity whose main traffic was going down this very narrow public road to the premises during July and August. And so the board had direct evidence that the traffic study was not accurately based upon when the traffic load was particularly um, uh, problematic and therefore raised questions about whether the project should be approved. So there can be circumstances where there is a report by an expert which the board can determine based upon their own assessment it's not a reliable report. You do have to give a written notice of decision. Um, you do have to state why you are approving or disapproving, and the decisions have to include findings of fact. And if you don't have findings of fact as to why you have said no to approve a project, your decision will be automatically overturned by Superior Court, and you'll probably end up paying attorney's fees. So if you plan to say no, be prepared to have findings of fact that support your decision, and that should be part of the written decision. And a tie vote is not a decision. So if someone makes a motion to approve a site plan and it's a tie vote for whatever reason, it's a board of 7 and you only have 6 members present, it's a 3-3 vote, you have not finished your job. That tie decision is not a vote to approve or disapprove. So someone's going to have to make a motion. If it was a motion to approve and it was a tie vote, someone else is going to have to take another motion to disapprove and to be able to get a vote that would have a majority of the members voting on that particular proposed motion. I do think it's important to always remember kind of the limitations on decision making by a land use board. The Dartmouth versus Hanover case is a good one to always keep in mind. The board's decision cannot be based upon personal lay opinions and anecdotes which are refuted for uncontroverted expert evidence. And if you may know the story of the Dartmouth versus Hanover case, the big issue in that case was whether this big hulking new athletic structure was going to create a situation where in the winter months it would cast such a significant shadow that the adjacent properties, residential homes, would lose sunshine for a good part of the day that normally they had during the winter months. That was the big issue. And Dartmouth actually had a shadow study, presumably done by an astronomer, showing that's not the case. The Hanover ZBA planning board said, yeah, well, we're still going to say no. So the board cannot supplant the specific regulations and ordinances that control the site plan review process with its own personal feelings. With legitimate evidence-based information, such as the Milton ZBA said, we know that traffic study is not accurate because we know it wasn't done at the right time period. That's a different story. So a few things that you do when you make a decision. Representations by an applicant are not binding unless they're clearly made as a condition of approval. So if during the process of receiving evidence, the applicant says, don't worry, I'm going to fix that section of land and put it in a little miniature park. And it's just a verbal representation. If you want that miniature park to be put in, and he's making that offer, put it in as a condition of approval. If you want it, you got to make sure it's written down. They have to relate reasonably to the proposed relevant criteria under your regulations. You could have a standard set of conditions, and the number of the towns that I used to represent would have a standard set of conditions which were all imposed in a notice of decision, which was recorded along with the approved plan, and the approved plan would be tied into the notice of approval. The approved plan would say, this subdivision or site plan is subject to, site plans are not recorded these days. So I'll talk about subdivision plans. It is subject to a notice of decision of even date recorded at, book and page. So they're all tied together. So the towns that I represented had standard conditions which were modified with modified specific requirements for that particular project. You could have a condition precedent. We're approving your plan subject to final engineering review, which might require a subsequent public board meeting. You can have conditions subsequent. This This Dunkin' Donuts is approved, but the squawk box and the outdoor drive up window has to be closed by 11 o'clock because we don't want loud noises projecting to the nearby residential neighborhood. And again, you could have a compliance hearing. If you approve the plan subject to final review by your engineer, you might have to have a compliance hearing, sometimes called a SCLAR hearing, where you have another hearing because the board can't just make a judgment as to whether or not the subsequent review by the town engineer satisfies the concerns the board has. You have to do that at a public meeting, and that's called a compliance hearing. So you'd have another hearing. Yes, you were subject to final approval with the board asking you to have the town engineer review it one more time. We've got the town engineer report. Let's go over it together and make sure everything is fine, and we're giving it final approval. Um, do know that there are new performance bond rules, that is, rules that govern requiring performance bonds meet certain requirements. You cannot require, a cash letter of credit or passbook as the only methods of security and compliance. Typically these days, many planning boards for performance bonds, which are covering the cost of public improvements, are usually provided by insurance companies, such as Liberty Mutual. You are now required to permit road and utility construction to start without a bond, um, but a bond for the infrastructure roads and utilities must be in place prior to the sale of any parcel or or a request for a building permit. Um, and bond release is now subject to a timetable you have to follow. And the municipal inspection for incomplete and non-compliant items has to be done within certain stated periods of time and timetables as set forth on the slide. So be aware of these limitations on performance bonds, the rules concerning performance bonds. The planning board has the right to make projects approved subject to certain grandfathering rights. So there's kind of two steps in the grandfathering statute. Projects that want to be exempt from subsequently adopted zoning and planning regulations. I'm not talking about acceptance vesting anymore. It's the project is approved, but maybe there's an amendment adopted after that point. They're exempt, but you got to do work within a certain amount of work within 24 months, and then you have to have it substantially complete within 5 years. So you can set forth what is the work they have to do within the first 24 months. And that's a worthwhile thing to consider. You also might want to have a requirement that to get substantially complete and therefore permanently vested, how much work has to be completed in terms of municipal improvements and or lots and or constructed or built. So when you make a decision and someone has agreed by your decision, the applicant, if the proposal is a uh, project for housing, can appeal to the Housing Appeals Board. That option is available either to the Housing Appeals Board or to the Superior Court, but you can't backtrack and start over again and go to the Superior Court if you don't like what the Housing Appeals Board did. You're either stuck with one or the other. And the Housing Appeals Board, essentially, decision-making process is very similar to the Superior Court. And then Superior Court appeal is now all focused on one land use board docket handled by a Superior Court Justice Michael Class. And he has a very substantial docket of just land use cases along with many other cases. He has a certain timetable by the orders of the supervisory judge in charge of Superior Court. I can't speak to the speed at which the land use docket is occurring, but the idea was to have one Superior Court justice who's dedicated just to land use cases. That's supposed to speed up the process and result in more timely and accurate decisions which are done by a judge who is entirely devoted to not completely, but mostly devoted to handling land use cases. So that's the completion of the presentation that I have with information about contact. Most of you are members of the New Hampshire Municipal Association. Municipalities are. Actually, all 234 cities and towns are members of NHMA, so you can contact us for legal advice and legal inquiries at newhampshiremunicipal.org and or by telephone. And so we have left about 10 minutes, maybe a little bit more like 12 minutes for questions, and happy to address those now.
Yeah, perfect.
Brendan?
Thank you. Yeah, thank you so much, Steve. Really appreciate the presentation. Yeah, we've got about six or so questions in the chat. I'm just gonna start from the top. Let's see. So we had a question from slide 25 about offsite exactions, I believe. So this person asked, what about fire protection offsite, like cisterns or dry hydrants for a project?
It's not going to be an offsite improvement, but I don't think it'll qualify either as drainage or highway or sewer or water. So I'm afraid I don't think that can be part of an offsite exaction. How you might require that in some other way under subdivision regulations, you're probably going to have to consider how to get that done with the advice of your regular municipal legal counsel.
All right. So the next question, I believe, came from slide 27, effect of planning acceptance. And the question is, does the planning board need to vote on whether the plan is complete?
Yes, it must vote that the plan is complete, and it should be just one motion. We vote, Madam Chair, that the plan has satisfied the checklist of items in our regulations, and we've deemed it to be complete and accepted as a completed application. That's all part of the same motion.
All right. And then the next question is in regards to newspaper notifications. So if the requirement for a newspaper notice is in the regulation of the town, but all local newspapers have dissolved, what can we do?
Consider amending your regulations so you don't have to have newspaper notification. But what you do is you may have to use one of the statewide newspapers, which are more expensive, but that could include the Union Leader.
All right. And let's see, I believe this question came from slide 29. Is there a listing of planning board duties for municipalities that don't have a master plan?
Um, well, okay, yeah, I mean, I guess if you don't have a master plan, um, then you don't have a zoning ordinance. So, I guess um, there are some towns that I suppose the planning board's role is pretty significantly circumscribed because without a zoning ordinance, um, the planning board, if it's got subdivision approval authority, so the town has voted subdivision approval authority without a zoning ordinance, the board's ability to approve subdivisions is pretty circumscribed, but you could still have a town that's approving divisions of land because you have to, because the planning board exists. The notice had been given to the registry that you have to have a signed plan by the chairman of the planning board to record that plan, but you're not going to be imposing zoning requirements as part of that subdivision approval. There could be other things that you have to address, but it wouldn't be zoning. So yes, that's theoretically possible. I know a number of towns in the North Country are in that situation.
All right. And so the next question, it's a little longer. Question on the 65-day rule. If a plan application is accepted and opens public hearing, but the board requires additional information and must continue at subsequent meeting while the applicant produces the additional information, how does the 65-day rule apply if the applicant takes longer than 65 days to provide the additional information? I think you kind of went over some of that.
You're stuck. You're either going to approve the plan or disapprove it because you think the material, the lack of the information is material to a decision, and you make a decision accordingly. Uh, or you say, well, we have incomplete information, and all we can do is deny the plan without prejudice. So those are really your only two options. The the you know the applicant's inability to get the information to you in a timely fashion might be enough for you to convince the applicant to give you an involuntary extension of time. And that might be the way to address the issue, especially if you've indicated that, well, if we don't have this information, we're probably going to have to say no. That might motivate the applicant to say, okay, well, I'll give an extension of time. So ask for an extension of time. And if you do, get it in writing. Don't rely on the minutes.
All right. And so we got three more questions, so I think we should have plenty of time. So can the planning board ask for alteration of a terrain permit?
Well, the planning board can't require an alteration of terrain permit unless that is deemed required by RSA, I think it's 485-A:17. So the necessity of an alteration of terrain permit is dictated by state law. So an applicant's need to get an alteration of terrain permit is triggered by the amount, if my recollection is, and don't hold me to this because I haven't looked at the statute in a long time, but when the application is going to change the contours and other impacts on more than 100,000 square feet. So that's something they're going to have to get. And you might put it in your checklist saying, final approval is contingent upon getting state permits approvals, and then the applicant has to get the state permit. But you can't make someone get an alteration of terrain permit if it's not triggered as required under state law or administrative rules.
Okay. So let's see. This question is rather specific. So I'll ask it, and you can kind of choose how you might want to approach it. But and it's a little bit of a long one. So an abutter objected to an auxiliary driveway application because the chosen site would impact their home with headlights shining in the windows. Turning trucks would end up using the abutter's driveway to get into the new driveway. The abutter had already experienced both of these negative impacts when the applicant used the area to park visiting trucks. The abutter pointed out other options for auxiliary driveway on the property. Would it be reasonable to deny the driveway property, or I'm sorry, driveway permit, given the negative impacts and other existing options?
That is such a common request that I've seen so many times in front of the planning board. This driveway location is going to have headlights of departing vehicles shining directly into someone's house across the street. That's not an unreasonable thing for the planning board to say. You should consider the applicant should consider moving the driveway. Of course, there are a lot of variables. What do we mean in terms of moving the driveway? It could be that the driveway's only got one reasonable location based on topography and ledge and other attributes. The other problem you might face is, what if this is a driveway in a state highway? The town has no control over the state highway driveway permitting. And also, it could be the case that the driveway change, as proposed by the abutter, uh, might impair the driveway's ability to have proper line of sight. So there are a lot of variables that come into play here. Um, and I guess my experience has been, geez, is there a way to ameliorate the impact of the headlights on the abutters, shining into their windows? And perhaps that amelioration could be the developer agrees to install some landscaping and trees on the abutter's property to minimize this. I think there's a number of solutions there might be there, but at the end of the day, if it is concluded by the board that this situation is not reasonably ameliorated with some modification by the applicant, and there are other variables that prevent it from the driveway being located other than as proposed by the applicant, it may turn out that the board has to end up either saying yes to the developer or no, or vice versa to the abutter. I can't really make a call on it. I think those are the things that the board would have to take into account in making a sound decision.
All right. Yeah, fair enough. And the final question that we have is, what is an agricultural preservation restriction?
So it is not uncommon for municipalities through either easement protections for certain uses or the state of New Hampshire through desiring to protect agricultural uses will have imposed easements on property to permanently ensure the property will be available for agricultural activities. So it could be similar to a conservation easement or easement for other perhaps recreational purposes. So it's simply just a restriction of land, which runs with the land, is recorded at the Registry of Deeds on record, and therefore is something that notice has to be given as required by the statute under RSA 676:4.
All right. Uh, well, excellent. I think that's all the questions we had for this session. Thank you so much, Steve. Here, I'm gonna take control really quick, and I'll progress the slide. So we've got a short 15-minute break here, and the next session will resume at 10:30. But yeah, just thank you again, Steve, and Steve will also be around at the tail end of the day. So if anybody thinks of any questions, throughout the day, Steve will be available to answer some more questions towards the end of the day. So
And
yeah,
and thank you. All right.
yeah. All right. All right. See everybody back in about 15 minutes.